A security guard calls the police and tells the officers that he sees several individuals on bicycles using flashlights to look into vehicles, and he is worried that they're going to burglarize them. Officers arrive to the scene, but they find nobody in the parking lot. So instead, they walk to an adjacent parking lot, and there they find an individual sitting in his vehicle. So now we have no bicycles, no flashlights. Nevertheless, they approach this person, begin talking to him, and find out that this individual is on parole. And then they proceed to search the vehicle and find some incriminating evidence. Is this a violation of the Fourth Amendment? Was there any reasonable suspicion that this individual was committing a crime? Well, the answer is no. This was an innocent bystander. There was nothing to connect him to the crime. But what about the fact that he's on parole? Would that help the officers in validating their search? Let's find out after this short break. And before we go on, I want to thank you for watching me on YouTube. Please hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. And finally, if you want to support this channel, consider going to LAWSTACHE.com and check out some of the merch, including the Do Not Arrest This Person t-shirts, hats, and other items. Thanks for watching.
Quick message from LawSTACHE. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the LawSTACHE YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the LawSTACHE YouTube page. That's LAWSTACHE.
Today we're discussing a California Supreme Court case, the People versus McWilliams. Let's briefly discuss the facts. In the evening hours, police officers receive a report from a security guard about some suspicious activity at his parking lot. He saw two individuals on bicycles flashing their flashlight into parked cars, so he suspects that they were trying to burglarize vehicles. An officer arrives to the scene but doesn't see anyone at the parking lot. He walks over to an adjacent parking lot where he sees Mr. McWilliams sitting in his vehicle, leaning back. He doesn't have a flashlight in sight, and of course there are no bicycles. Nevertheless, the officer asks Mr. McWilliams to get out of the car and show his identification. So this is the initial detention. Mr. McWilliams complies, and the officer does a records/background check on Mr. McWilliams. Turns out that Mr. McWilliams was on parole. With that information in hand, the officer conducts a search of Mr. McWilliams and his vehicle and finds narcotics, a firearm, and additional drug paraphernalia. Mr. McWilliams argues that that evidence cannot be used against him in the court of law because it was found in violation of the Fourth Amendment. But the government relies on what's called Attenuation Doctrine. Before we go on, let's focus on the basics. The Fourth Amendment provides that you have a right against unreasonable searches and seizures. And of course, the way we enforce this right is with what's called exclusionary rule, meaning that evidence found in violation of the Fourth Amendment cannot be used against you in court during trial. But there's also a doctrine of what's called attenuation, which means evidence is admissible when the connection between the unconstitutional police conduct and the evidence is remote or has been interrupted by some intervening circumstance, so that the interest protected by the constitutional guarantee that has been violated would not be served by suppression of the evidence obtained. There is a three-part test. First, we have to look at the temporal proximity between the unlawful conduct and the discovery of evidence. Number two, the presence of intervening circumstances. And finally, number three, the purpose and flagrancy of the official misconduct. All parties now agree that the officer violated the Fourth Amendment when he ordered Mr. McWilliams out of the vehicle and detained him without any basis or reasonable suspicion that Mr. McWilliams committed any sort of crime. Now, there are two Supreme Court cases that are relevant here. Brendlin and Strieff were similar in the fact that the initial detention was illegal, but later the officers found that there was a warrant outstanding for an arrest of those individuals. The Supreme Court held that even though that initial detention was illegal, the warrant commanded the officers to arrest the individual and thus search that person. Here we have something slightly different. In this case, we don't have a warrant, we have a parole. And parole and supervised release are different in the fact that they don't command the arresting officer to conduct a search. Parole only tells the officer that he could do it. And so here the question is, does the attenuation doctrine apply? And so looking at the three factors, the first factor is of course the temporal proximity, meaning looking at the time between the initial illegal conduct and then the search. And here all parties agree that the search happened right after he asked Mr. McWilliams to step out of the vehicle. So there's really a short period of time, seconds, maybe minutes, but the court and all parties agree that the temporal factor weighs in favor against the attenuation doctrine, meaning the exclusionary rule should apply. Now moving on to the second factor, the parole search condition entails no compulsion but instead invokes law enforcement discretion. It raises greater concerns about the course of events connecting the unlawful stop to ensuing search. There's a danger that the officer who has unlawfully stopped a bystander without reasonable suspicion will regard the discovery of a parole search condition as a license to continue pursuing a baseless hunch, rather than fairly considering whether a search is appropriate to assess the individual's rehabilitation and monitor his transition from inmate to free citizen. It suffices to conclude that in this case, where the same officer who conducted the illegal detention also decided minutes later to conduct a parole search that yielded incriminating evidence, the discovery of the parole search condition did relatively little to break the causal connection between the two events. And finally, as to the third factor, the flagrancy and purposefulness of the misconduct, here the court says there was no connection between Mr. McWilliams and the crime. He was just in the vicinity of the area. There were no flashlights, there were no bicycles, nothing that the security guard told the officers in his initial report were present when the officer arrived and saw Mr. McWilliams. And for that reason, the court said all of the factors weigh against the government, and so the exclusionary rule should in fact apply, and the evidence found against him should be suppressed from court. And of course, if we're suppressing the narcotics and the firearm, it is likely that all of the charges should be dropped as well. If you enjoyed this video, please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know. And if you're listening to the podcast version of this recording, give it a 5-star review rating. And finally, again, if you want to support my channel, go on LAWSTACHE.com and look for my merch, including this Do Not Arrest This Person t-shirt. Thanks for watching.